allowing the federal and the constituent units to work in an independent fashion. So that is the main, the main characteristic features of federalism. Now, having said so, we understand that because there is a demarcation of jurisdiction between federal and the constituent units, there is going to be some kind of tension between the federal and the cooperating units. Now, competitive federalism is something it is a very specific characteristic of the old forms of federalism or old models of federalism, which were very much in the line of classical federal model, because in classical federal model what we find is that different constituent federal units come together, yield some of their power to the federal structure, and thereafter they form the federation. Now, what you will find is that generally in the old model or old examples of federalism, or even in present federal structures, if you go back in the history of their federalism, what you will find is there was some kind of competition between the federal and the constituent unit, wherein each of them tried to assume more and more power to itself. And this happens whenever there is any decentralization. The balance of power has to tilt in favor of someone, and there is always some kind of tension between different jurisdictions per se. Now, competitive federalism is an example of such a form of federalism wherein there is a constant competition and struggle between the federating unit and the federal unit and the constituent unit to assume more and more power itself. Okay, when I'll just repeat what I was saying. So, nothing much, I'm just trying to introduce the idea of competitive federalism to all of you, and the idea of competitive federalism is that there is always this constant struggle between the federal and the constituent unit, or let's say in India's example, union and the state. So there will be a constant tug of war in order to assume more and more jurisdiction, more and more part to itself between the demarcated jurisdiction. So that is what competitive federalism is about. Many of the present federal structures in their initial stages suffered, or at least, okay, my voice is breaking. And then maybe I'll just sign out and rejoin again. Yes, okay, thank you very much. Now, okay, some of you are joining by not using your DUID. So just let your friends know who want to be a part of this class, so that you can join or be a part of this classroom, but just try and use your institutional ID to do that. And if you do not have an institutional ID, then please drop an email to me, and then I will add you to the classroom. So that would facilitate attending the class without me being disturbed in between. So just let your friends know. Yes, Manisha, I'll go slow. So let's start from the very beginning. So what we are discussing today is competitive federalism, cooperative federalism, and asymmetric federalism. Now, competitive federalism, and will be in the initial part of a discussion will be focused on competitive and cooperative federalism. Now, what do you mean by competitive federalism? In order to understand that, you need to understand the very idea of federalism first. Now, we have devoted 1.5, 2 lectures to understanding what federalism is about. And we understood that federalism is primarily about decentralization of power. And decentralization of power in a vertical manner, right? The vertical decentralization of power. Now, we had also discussed that all forms of decentralization of power does not automatically mean that it is federalism. Federalism is just one of the many forms of decentralization of power. You also find different forms of decentralization of power. For example, something called separation of power, which is a horizontal decentralization of power, is also a decentralization of power. But we are not concerned with... okay, Vinay. Is my voice breaking for everyone, or is it just Vinay who is facing that problem? Okay, for everyone. Okay, just give me 1 second. I will just sign out and rejoin. Okay, I'll just sign out and rejoin. Okay, I hope I'm audible to all of you now, and I hope my voice is not breaking. So I will try to go slow because my voice is breaking, but if it is, then I think there is some connectivity problem either at my end or at your end. Okay, now let's go back to our discussion on competitive federalism. So now what we were discussing was that federalism is about vertical decentralization of power, and it is also about demarcated jurisdiction. Now when you demarcate jurisdiction, what you are basically doing is dividing the power. And whenever the power is demarcated or divided, it is an obvious experience that we find some kind of struggle or tussle or conflict between different units between whom the power is demarcated. And we find that, for example, even in the horizontal decentralization of power, which we know as separation of power. For example, you find a tussle between executive, legislature and judiciary vis-a-vis who should have power to do what, right? And this is something which is very obvious even when you are talking about vertical decentralization of power, because you will find this constant struggle or conflict between the union or the central government and the provinces or the state government with respect to who should get more power to determine how they want to function. Now, what you will find is that historically in our experience, most of the older examples of federalism or those federal structures, polities in present world, in their initial formative years, found this struggle to be very pronounced struggle between the federal unit and the constituent unit. And therefore, such eras were marked with too many intergovernmental disputes, too many disputes between the federal government and the provincial government, or the central government and the state government. But subsequently, what happened that our idea of federalism globally underwent a change. And today, the concept of federalism that is more pronounced is the concept of cooperative federalism. Now, what is the meaning of these cooperative federalism? Now, if you look at the book of MP Jain, book by MP Jain, you will find that MP Jain ascribes the transition from competitive federalism to cooperative federalism to three important reasons. The first important reason being that because we faced a lot of exigencies of war, what happened was that in war you need a lot of resources, and many times provinces will not have ample resources to sustain themselves during war, and those provinces or states will have to rely on the central or the federal government to sustain themselves during the war. And that is an important reason that marked the shift from competitive to cooperative federalism, because the only manner in which the state or the provincial government can survive exigencies of war is not if they are indulged in constant struggle with the federal or the central government, but rather if they are cooperating with the central government so that they are in a better bargaining position to get the required resources from the central government. Because, as I said, provincial governments will not be as self-sufficient or powerful as the central government, okay, or they may not have access to some important resources. So that is one important reason which, if you read MP Jain's book and you open the chapter on, there is an entire chapter dedicated to cooperative federalism, you will find this example being mentioned there. So that is one important factor ascribed that MP Jain thinks led to a shift from a world where dominant concept was competitive federalism to a world where dominant concept is cooperative federalism. The second is obviously advancement in technology. Okay. Now, because you have better technology, better way to communicate, the channel of communication between the central and the states are much more open and much quicker and much faster. And it helps the central to obviously exercise more control of the provinces, and also for the provinces to be in a better bargaining position vis-a-vis the center, because that channel of communication is open, which makes communication faster and which sort of prevents decision making in haste or decision making built on prejudices or assumptions, and that is something which led to the advent of cooperative federalism. And the third important aspect, and which is a very important point as to why we shifted from competitive to cooperative federalism, is this birth of the idea of welfare state. Now, if you remember, and if you follow the philosophy of liberalism very closely, what you will find is that liberalism as a philosophy has also undergone several transitions. Now, the classic liberal model, which we often known as libertarian model, believes in minimum state intervention, and that is why a classic liberal model or a libertarian model of a state would confer on state primarily negative obligations and not positive obligations. Now, what do I mean when I say conferring negative obligation on the state? I mean to say that the obligation on the state will be to refrain from doing something, not to go ahead and fulfill its obligation. So, for example, if we say that right to equality is a right guaranteed to the citizens against the state, if we understand right to equality from a negative obligation perspective, what we will argue is that the state is only bound not to do something which violates your right to equality. So state action per se would not interfere with equal treatment of individuals. Now, what does positive obligation mean? That it is not just the responsibility of the state to ensure that equal treatment of individuals is not in any manner disrupted state action, but the state must take additional steps to ensure that individuals are placed at an equal pedestal, equal level. So that is where the concept of affirmative action or positive obligation comes into picture. Similarly, every right has a positive and a negative aspect. If you look at part 3 of the Constitution, you can very well categorize right majorly, not entirely, but more or less into negative and positive obligation, wherein part 4 is primarily about positive obligation, but it's because it is directing the state to do something, to take an action. And part 3 is more or less, major part of part 3 is about asking the state not to interfere, or not to do something. So if you look at the initial stages of why I'm giving you such examples so that you understand what was the initial idea of liberalism, that the state will refrain from interfering. And that is what was the laissez-faire model of the state. Minimum state intervention. The state should not intervene. So the primary obligation of the state was to not intervene, right? Now, over a period of time, this entire idea, the idea of a liberal state also underwent a change. And that happened because of several reasons, wherein we found this classical liberal or libertarian model failing when there was a Great Depression. We found the advent of socialism and communism, which interacted with liberalism, and eventually we came up with the concept of this something called welfare state. Now, what is a welfare state? A welfare state believes that the obligation on the state is not just not to intervene or not to act in a specific manner, but the obligation on the state is also to provide for. So the state is also a provider. The state is not just a mute spectator, which is outside the framework of how a society is operating, and the only role of the state is to provide an overarching regulatory mechanism. Rather, the state is also a provider, and the state has to provide. Now, once we say that the state has to provide, that means that the state needs more resources. That is the only possible way of state being a provider. Now, why do resources become important when we talk about positive obligation? And the best example that you can get in Indian context is the debate in the Indian Constituent Assembly as to why directive principles of state policies are unenforceable and fundamental rights are enforceable. Now, initially, if you look at the Constituent Assembly debate, the idea was not to segregate rights into Part 3 and Part 4. But eventually, so it was a combined, a unified kind of a code of Bill of Rights in the Constitution, which did not have this separation between enforceable and unenforceable rights. But what was realized subsequently was that many of the rights that we now have as part of Part 4 of the Constitution, that is directive principles, could not have been ensured and guaranteed because that required the resources in the hands of the state. And until and unless state itself had resources to provide for Part 4 rights, it would make no sense to make Part 4 rights enforceable, because the state did not have ample resources to guarantee and provide for Part 4 rights. And that is one of the reasons why this entire scheme of rights in the Constitution was divided into Part 3 and Part 4. Now, why I am citing this example? So that you can understand why when you are casting a positive obligation on the state, you need to also ensure that the state needs to ensure that it has ample resources in order to ensure implementation of those positive obligations. Now, so one of the important reasons, therefore, why we shifted from competitive to cooperative federalism was because of this advent of welfare state model, wherein the state is now being expected to be a provider as well. Okay, so you have to provide. For example, a welfare state model would argue for minimum health guarantees, minimum social security guarantees, right? So those basic guarantees are required. So even in states or a free market economy like US, we still have discussions about minimum health benefits and some kind of social security schemes. Social security welfare measures can only be provided by a state which has ample resources. Now, if we are talking about a welfare state in an era of competitive federalism where the federal and the provinces are continuously fighting with itself with regard to assumption of more and more power, obviously the provinces would be in a worse situation, and even the federal government, because they will not be able to come to a decision with regard to allocation of resources. So what you require is that the federal government or the union government sort of tries to allocate resources among all its constituent units in a fair and equitable manner. And for that, it is important that there is a continuous dialogue and cooperation between the provinces and the federal government, or between the state and the union. In the absence of that dialogue and cooperation, and if the relationship between the union and the states is marred by constant struggle, what will eventually suffer is this idea of welfare state. Okay, so that's why this is one of the most important reasons which sees a shift by the present dominant ideology governing federalism is the concept of cooperative federalism and not the concept of competitive federalism. Because what it does is it minimizes the struggle, the friction, and the constant tussle of power between the central and the state units. And what it ensures is that all the constituent units can use their resources and equitably divide their resources for the betterment of the nation as a whole. And that is the importance of the idea of cooperative federalism. Now, if you have understood the difference between competitive and cooperative federalism, let's just take a journey through the text of the Constitution to understand, and it's going to be a very brief overview of the text of the Constitution to understand as to what are those specific portions of the Constitution that indicate that perhaps Indian Constitution is an example of cooperative federalism and not an example of competitive federalism. So let's start with something called Article 263. Okay. Now, if you look at Article 263, Article 263 provides that the President can appoint an interstate council. And what is the relevance of this interstate council? The relevance of this interstate council is to basically negotiate or settle the disputes which arise between different states in India. Okay, and make recommendation as to what is the best way of coordination between the states. Now, that ensures that whenever there is a conflict between states or between the state and the union, in the case of interstate council between the state, the union government acts as a moderator or a mediator in order to mitigate or resolve the conflict. Now, that ensures or that helps in not only strengthening the relationship between state and state, which is known as horizontal relationship in federalism, but also between state and union or the central government, that is known as vertical relationship in federalism. So this is one example of how Indian Constitution talks about cooperative federalism. Then the second example is different water tribunals which have been constituted. Now, all those water tribunals which try to resolve interstate water disputes, and especially there is an Interstate Water Dispute Act as well, 1956. Now, what that does is that it allows for the adjudication of all conflicts with respect to allocation of water resources. Now, if you have a look at Article 262, you will find that Article 262 is empowering the Parliament to make a law for adjudicating any dispute that may arise with respect to use of water resources or distribution or control of water resources. And there are several acts which are made in this regard. For example, River Boards Act, Interstate Water Dispute Act in pursuance of Article 262, which ensures that water disputes do not become a cause for continuous conflict between states per se. So that is something again which is an example of cooperative federalism. Now, apart from that, what you will find is that there are several statutory bodies which are constituted, like UGC. Now, what UGC does is that it sort of tries to University Grant Commission. It sort of tries to provide a homogeneous form of education system across India, such that the standard of education everywhere is one and the same. Okay, that is something. So it coordinates and maintains the standard of education across India. Now. And this is something, now what, if you look at and this is something that we will discuss when we are discussing the three list and the distribution of legislative power between the center and the states, what you will find is that there is neither the center nor the state have complete control over education. Different aspects of education are divided between center and the state. Now, in the presence of such division of power with respect to different aspects of education, it may create a lot of trouble when you are trying to coordinate center-state relationship. Now, University Grant Commission, what it does is, or a centralized body like that, what it does is it tries to minimize that area of conflict by providing a sort of a homogeneous standard of education. So, and that is another example of cooperative federalism per se. Apart from that, for example, we also had planning commissions, and now we have Niti Aayog, wherein both the state and the center sort of have equal participation. Whether they have or not have is a different thing, but at least in a procedural manner, it is tried that the representatives of the state have equal voice as compared to the representative of the center. Even if you look at this entire GST debate, and before GST was finally made applicable, the entire debate was with regard to representation in the GST Council, Goods and Services Tax Council, as to what is the importance of representation of the state representatives in the GST Council, and eventually the state was given as much importance with the representation in the GST Council as compared to the center. Apart from that, for example, you also have something called Article 245. Now, if you look at Article 245 and you also look at Article 261, what Article 245 says that every state's jurisdiction is confined to its own territory. Okay, that means the jurisdiction of the laws of, let's say, Assam will not be applicable on Gujarat or vice versa. Laws of Himachal will not be applicable on Kerala and vice versa. But that does not mean that the laws of Himachal will not be respected in Kerala per se. So, for example, if there is a case in the Kerala High Court that deals with a law of Himachal Pradesh, then the Kerala High Court is going to consider the law passed by Himachal Pradesh to be a valid law if there are no other by procedural irregularities or substantive irregularities which can be cited. So that means that laws of different provinces in India, different states in India would be given respect, full faith and credit. And that is why Article 261, if you look at Article 261, it says that full faith and credit will be given throughout the territory of India to public acts, records and judicial proceedings of the union and the state. That means that judicial decision, let's say of one high court, is going to be considered the law, at least with respect to that specific state in the other high court. So that is how you give full faith and credit to public acts, recordings and judicial proceedings. That ensures that the sense of cooperation is maintained. So obviously we are not going to extensively deal with the nuances of these different aspects, because that will be taking up during the course of our discussion as we go through the syllabus, but just some examples of cooperative federalism in Indian Constitution. And what you need to realize is that more or less the dominant idea of federalism in India is cooperative federalism. It is not competitive federalism. So you may find several conflicts emerging, but this concept or idea of cooperation is something that guides resolution of disputes between center and the states or between the states, among the states themselves. Now, having said so, and in case you have any question with regard to cooperative and competitive federalism, let me know. Otherwise, I will move to the third concept that we will to discuss today. Okay, so if you do not have a problem with cooperative or competitive federalism, what we can do is let's take up the example of asymmetric federalism. Okay. Now, those who want to read more on cooperative federalism in much more detail, they can pick up MPGen, book or MPGen, and MPGen has an entire chapter on cooperative federalism. Now let's come to asymmetric federalism, and I hope some of you got an opportunity to go through the one of the chapters or one of the readings that was uploaded on the classroom. That is Asymmetric Federalism by Louis Tillin, which is a part of this Oxford Handbook on Constitutional Law. And this specific reading will at least give you a brief overview and a brief idea of what asymmetric federalism is all about. Now, as the term asymmetry itself suggests, asymmetry means that there will be different rights given to different constituent units of a federal structure, right? That the decentralization of power is not symmetrical in nature; it is asymmetrical in nature. There are some of the constituent units will get more power as compared to other constituent units. So that is the main crux of asymmetric federalism. Now, once we understand that asymmetric federalism is about differential treatment being given to different constituent units, what you also need to understand is that differential treatment is not generally a negative concept. Sometimes differential treatment allows the federal structure to achieve more cohesiveness. Okay, and how that is done is something that we will understand. Now, there is a very famous book written by Alfred Stepin, Juan Linz, and Yogendra Yadav, and the title of the book is Crafting State Nations. Now, Yogendra Yadav, you will find Yogendra Yadav often arguing that India is a state nation and not a nation state. So even if you have not read the book, you may have come across articles wherein he seems to argue that India is a state nation and not a nation state. Now, this entire concept of state nation, which is given in this book, and it's a very interesting read for those who want to understand and try to shift from the Eurocentric idea, the Westphalian idea of nation state, and try and understand that there are different ways of organizing a nation as well, and that need not be the idea of nation state, because nation state was basically based on the concept of homogeneity. Okay, that there will be one culture, one language, one religion, and that is how this idea of nation state evolved, and that was very much possible in a polity like in a political climate like that of Europe, where diversity per se was not as stark and not as numerous like in India, in a country like India. But what is often argued by those who challenge the Eurocentric model of nation state, that this idea is not very much applicable in non-European context. For example, in Asian context, where if you take the example of India, India being a land of diversity per se, so we are defined by diversity and pluralism. So in such a scenario, it becomes very difficult to just replicate the nation-state model of Europe and in India. So what is often argued, therefore, is that India is not an example of nation-state. At least this is an argument given by 3 people in one book, that India is a state nation. And the basis and the logic behind calling India a state nation is based on this concept of asymmetric federalism. Okay, what is being said is that, and what is often argued. Now, there is another article that I have uploaded that has been uploaded on your classroom. That is asymmetric federalism basically an alternative to secession by William Pavlika. Another very interesting, is federalism a viable option to alternative to secession? Now, why do we need asymmetry in federalism? The reason being that the asymmetry allows you to accommodate diverse aspirations and values. That is one of the most important reasons why we need some kind of differential treatment. Okay, because you have to understand that different constituent units may not be aspiring for the same thing, despite the fact that there will be some kind of uniformity in the expectation of all the constituent units who form a part of the federal structure, but it is not necessary that the needs, wants, desires, aspirations, and even the values and the cultural, historical, political context that they come from be the same. Now, in order to accommodate these views and so that those views are not marginalized by the dominant views, what is required is differential treatment and some kind of asymmetry in the structure. Now, that is the crux of asymmetrical federalism. India can be considered to be an example of asymmetric federalism, specifically if you go into the history of how different states became a part of India and how different states have been provided or meted out differential treatment in order to accommodate their viewpoints. Now, Northeast is a very good example of how asymmetric federalism operates in India, and that's why we generally tend to argue. There is a very strong argument for creating a Northeastern exceptionalism in India, because what you will find is that there appears to be a lot of diversity in Northeast in itself, and all those diverse nations have been given some kind of autonomy in Indian Constitution in order to allow Northeastern states to maintain their exceptionalism or maintain their specific cultural specificities. So that is what. If you want to study asymmetric federalism in India, a very good universe to study that would be Northeast states, and how asymmetric federalism has helped India in sustaining a federal structure. Now, having said so, what you need to understand is that there are several examples of asymmetric federalism in India. So, if you understand asymmetric federalism as a concept, let's also move to different arguments which are given in favor of asymmetric federalism. The strongest argument that comes from several writers, including a discussion in one of the articles that I have shared with you, that William Kimlicka, is federalism an alternative to secession, is in the form of federalism mitigating secessionist tendencies. So the only manner, according to some authors and scholars, that a federal structure can remain cohesive, especially if the federation is in itself diverse and plural, for example in India, would be if you allow differential treatment to sub-constituent units. If you do not do so, demands for secession would run high. The only manner, or that's the only viable medium to ensure that secessionist tendencies do not gain ground, is that if you allow or provide for differential treatment. Such differential treatments are found several places. For example, in Canada, you have this entire region of Quebec, which is French-speaking Canada. So if you go to Quebec region, the kind of differentiation that you will see is that generally in the rest of the Canada you won't find French signboards, but in Quebec most of the signboards, French is an essential language in which the signboards are there. Now, such kind of linguistic differentiation is something that you also see in India. For example, every state has a different language, right? So with every state that you move in, you will find a different signboard, a different language being used on the signboards. Now, why am I giving you example of, let's say, Canada and India? Because you need to understand is that language can be one of the very important grounds on which secession operates, apart from religion or apart from different cultural background that a specific area comes from. Now, what is argued by several authors is that in order to ensure that secession along these lines do not gain a lot of ground, it is always viable to provide for differential treatment of such units, constituent units, and gives comparatively more autonomy and more protection to these constituent units, so that they more or less remain the part of the federation, but at the same time their cultural, their specific aspirations are also realized. So that is one of the main reasons why asymmetric federalism has been experimented by several countries, especially those countries which boast of plurality and diversity in the values and are not homogeneous per se. Now, as I told you before, the three examples that we will be discussing, and the three examples again which are quoted in that Lewis Tillotarian articles, is that we will be discussing with respect to this specific asymmetric federalism in India is first is 5th and 6th schedule, okay, 5th and 6th schedule. The second is special provisions which have been provided to different states for different reasons, and these special provisions can be found in Article 371 to 371J. So special provisions being provided to different areas or different states, and what is the reason for providing that special provision? And the third, obviously, is Article 370, which is again in controversy right now because it has been abrogated. But we can at least look at the legislative history of Article 3 and historical history of Article 370 to understand what was the reason for why Kashmir was given a separate status altogether, and whether all these three examples. We can also argue and comment and discuss whether all these three examples have better helped us in ensuring that the Republic of India, the territory of India remains intact, at the same time meets the aspiration of different people, diverse people, or has it not worked in the favor of either meeting the aspirations of diverse people coming from diverse background and for maintaining that entire idea of integrity of the territory of India. Okay, there's a question. Repeat this part. Okay, which specific part, Soumya? Can you just let me know which specific concept did you not understand? Is Soumya there? What is it that you want me to repeat? Which part? Okay, I will just try and at least repeat the last 5 minutes that whatever I was discussing. So what I'm arguing, what we were discussing was that okay, plurality. Yes. So see, why would you? Now you have to ask yourself a very simple question: why would you need to give differential treatment to different constituent units? Now the only reason why you need to give differential treatment is that there is some kind of difference either in the status or in the aspiration or in the values of the different constituent units. Okay, it is not always necessary that the aspirations of the state meet with the central government, okay, or meet with India as a whole. It is not always necessary, and we have seen several examples of the same, where we find different kinds of aspirations being reflected, which is not per se in sync with the mainstream idea or the mainstream aspiration, something that is projected as the mainstream aspiration of India as a whole. In a plural country, specifically a plural democracy like India, wherein we come from different cultural, religious, linguistic backgrounds, there may seem a point that if you accord same treatment to all the constituent units, some of the units would feel that a mainstream narrative is being imposed on them, or a mainstream idea of what India is being imposed on them, which happens even now, but that feeling will become much more pronounced. So what is generally done is that differential treatment is conferred on different units so that they retain some kind of autonomy over how they want to, what are the methods that they want to utilize to meet their aspirations, right? Now, that's why, not just India, I gave you the example even of Canada, where this Quebec region, which is, and if you look at Canadian constitutional history, you will find claims of or demands of secession by Quebec, wherein Quebec wants to completely secede from either Canada or at least have much more pronounced autonomy as compared to Canada. Why? Because it's a French-speaking province compared to other parts of the Canada, which is not a French-speaking province. So, that struggle is there in Canada itself. We find that even in India, many of the specific autonomous regions in Northeast, or let's say Kashmir, or you would say the Tamil movement, they argue for much greater autonomy. Now, the reason why they argue for greater autonomy is that they feel is that by being meted out the same treatment as other states are being meted out, which are not given differential treatment, they are not able to realize the aspirations because the historical political context is something that is not understood by the mainstream leaders. state is that in order to realize their aspirations, they need more autonomy vis-a-vis the central government. Now, this is the reason why many nations favor asymmetric federalism, because if it was not for this differential treatment, demands for secession would run high. Okay, that's why it is because then they the only demand. So if you are just in favor of symmetric federalism, wherein you are providing the same treatment to all constituent units, the same treatment not bode well with all the constituent units, because obviously different constituent units will have different aspirations. For example, every individual is not the same, so the treatment of every individual has to differ. Okay, the same manner treatment of different constituent units has to differ if you want to take into account their aspirations. So that is why we come up with asymmetric federalism in plural countries, or asymmetric federalism is considered a viable option in plural democracies and diverse democracies, so that calls for secession do not gain currency. They are not strengthened over a period of time because of the disappointment that several constituent units feel vis-a-vis the central government. So that is why this asymmetric federalism. I hope that clarified your conclusion, Soumya. Now, next we are coming to. Okay, we only have 8 minutes left and I have to start class. So what we will do is that we will briefly discuss the different aspects of asymmetric federalism found in India, and then we will have a detailed discussion of all these 3 aspects tomorrow. Now, the first aspect is 5th and the 6th schedule. Now, for a constitutional law student who wants to study federalism, 5th and 6th schedule are extremely important. Generally, we have this tendency of not studying these parts of the constitution and confining our idea of federalism to state and center, the mainstream narrative of state and center, wherein we are talking about per se specific mainstream relationship between state and center, that how the fiscal federalism, how finances are distributed, etc. But we are not talking about, or when we talk about federalism, maybe we will pick up Article 356 and try to study how federalism, dynamics of federalism under Article 356. But if you really want to understand how this Indian federal model works, you need to go deeply into the 5th and 6th schedule. Now, obviously, we will not be able to have a very long discussion of 5th and 6th schedule, but I hope that whatever discussion we have, we will at least understand the importance of 5th and 6th schedule to this concept of federalism that we have in India. Now, 5th and 6th schedule are specifically about were created in India in order to guarantee protection to several tribes in the northeast region. Okay. Now, the reason why several of these tribes had to be given protection was because their culture and their way of living had a very distinctive characteristic, and which did not merge with the mainstream cultural narratives and the mainstream way of living. And in order to accord them protection, it was extremely important to have something called 5th and 6th schedule, which sort of provides special measures for governance, for all the indigenous communities or scheduled tribes, as we call them, who live in the 5th and 6th schedules of the Constitution. Now, the reason why this was done was so that more autonomy could be given to those tribes. Okay, so that's why if you look at 5th and 6th schedule, you will find this provision for establishing tribes advisory council, wherein the tribes advisory council will be given much more power to determine what is the governance scheme, what is it that will govern these specific tribes. In 5th and 6th schedule, you will also find instances wherein the laws which are otherwise applicable across India may be exempted from application in these scheduled areas. The reason being because those laws would not meet the aspiration of these scheduled areas, and that is why this differential treatment being accorded to 5th and 6th schedule. More self-governance. So what we thought when we were talking about vertical decentralization of power in federalism, when we look at the mainstream idea of how power has been decentralized in India, and let's say we remove the 5th and 6th schedule from idea of federalism in India, you will find that local bodies and panchayats are not that well developed, or they have not been given that much autonomy. Despite the fact that we have something called NDPSC, and there were calls for establishing and giving more power to the panchayats and making villages a self-sufficient unit. At least the Gandhians argued for making villages a self-sufficient unit and a smaller republics in themselves, although that was not accepted. Okay, and subsequently, however, though panchayats were there, it was only through 73rd and 74th constitutional amendment that constitution itself sort of promulgated a framework for panchayats in Raj institutions. But despite that, because it is the state government which will devolve the power on the Panchayati Raj institution, you will not find that much autonomy which is given to Panchayati Raj institutions even yet. So the decentralization of power, more or less, the primary decentralization of power, vertical decentralization of power in India happens between the center and the state, and does not go down further to another unit at the village level. In fact, what you will find is that by 6th schedule, and for example, with the advent of the tribal advisory council, you will find a further decentralization happening, and that further decentralization is being done only for one specific purpose, to give more autonomy to these tribes, so that they are not at the threat of their culture completely disappearing, because they have to accord to the mainstream cultural expectations, which are also reflected in legal arrangements. So that is one of the very specific reasons why you have something called 5th and 6th schedule. Now, tomorrow we will have a detailed discussion on 5th and 6th schedule, and then you will perhaps understand better how these are important aspects of important in when we understand Indian federalism. Now, the second aspect of asymmetric federalism is special provisions which are conferred on some of the states. And every provision has been conferred on, special provision has been conferred on these states